Hi everyone, I'm Matt Lane. I'll be the moderator for this panel. I am a senior policy counsel at Fight for the Future. Before that, I was nice. In the beginning of my career, after I graduated law school, I was an antitrust attorney for a few years for a small firm, mostly working on advocacy before the FTC and DOJ. I was involved in one case with a bunch of other firms against Blue Cross Blue Shield. And that's basically it. I quit out pretty quickly because it's not a fun field for some people. But I will turn it over to Jim.
I'm Jim Nettles, so I am not an attorney. I had to play one on TV. I'm also already a little punchy this morning, sleep deprived. I am, by trade, I work largely in fintech. I am a partner in a consulting company. We deal with a lot of technology issues, do a lot of business development work. One of the things we've got underneath our helm is actually a digital marketing ad agency. That's not my side of the house. I'm on the infrastructure technology side of things, but I've spent most of my career dealing in this space. I have worked, full disclosure, I have never worked with Google. I have worked with a number of other firms. And so I regularly work in the space. I'll probably be talking about things from the business side of it someday.
So, hi, I'm Tien. I'm the legislative director for the Electronic Frontier Foundation. I wasn't always working on legislative stuff. I started out working as a litigator, both in the free speech space and then also in the national security surveillance space. I was on the litigation teams at the DFF that sued the NSA and AT&T over dragnet surveillance. But these days, I run our legislative program both in DC and across the state. If you were here with the previous panel, my state director, Amy Tien, was on that panel. So I'm not, however, a trust lawyer. I'm simply a general lawyer. One of the reasons why we're interested in these cases is because of both the competition side and the privacy side. Let me hand it back over to Cam.
So what I really want to do is to do a broad overview of where we're at and what the stakes are and what's going on. Antitrust is an interesting field in that it is fairly simple when you first glance at it, and then it quickly becomes very complicated, largely because antitrust lawyers like to make it very complicated. And then when you learn a lot about it, it becomes fairly simple again. So I'm hoping to maybe get you guys over that curve before we jump in audience questions. So Lee, I just want to start with you. Can you just give us a quick update on where we are with the Google antitrust?
So I think the first thing to remember is that there isn't just one case, right? So what we're going to be focusing on today is the case out of the district court in DC, with Judge Mehta, and that's about Google search. There are two other major cases. One is in the Eastern District of Virginia before Judge Brinkman, which deals with the area of ad technology separate from search. And then there's also a case in the Ninth Circuit, which is not a DOJ against Google. That is a case between Epic and Google that has to do with monopoly power in the gaming market and apps. So we're not talking about those. We're going to focus on Google search. Judge Mehta has found that Google is a monopolist with respect to general search and also general search in text ads. And so that's basically focused on the Google search function. And now we're in a part of the proceeding where the DOJ has proposed a remedy framework, and it's begun pre-trial briefing. There's going to be a lot of activity around what the remedies for this violation of the antitrust laws would be, and that's ongoing. The big thing to remember if you are not a deep into this stuff, is that there's really two types of remedies in antitrust cases. There are so-called behavioral or conduct remedies, which say, hey, you should stop doing this, or you have to do this in order to increase competition. But on the other side of behavioral conduct remedies are what we call structural remedies. And that's the thing like, oh, let's break off Chrome. Let's break off Android. That's actually taking pieces of Google and breaking them off. So that's sort of that's kind of the big debate is what's the mix of behavioral and structural remedies in the case. So I think the other easy thing to remember is that conduct remedies are sort of like, oh, if these were the bad things you did, now you should stop doing them. And then you think about, can we compensate people for those bad things? Like maybe there's some sort of liability involved. But then that usually, and this is what DOJ is saying, conduct remedies will not be enough to cure the harm. Google's been a monopolist for a very, very long time. It has a lot of advantages, and you may have to break something on. And because so much of Google's monopolistic advantage in this area is through the browser, through Chrome, through exclusivity agreements, and all sorts of things saying, if you're making a browser, if you're making a phone, if you're a wireless carrier, you got to make us the default. You've got to pre-install Google search. We'll pay Apple to not do certain things. But that may not be enough. And so then you might say, okay, let's divest Chrome. And that is actually one of the things that DOJ has proposed is a complete divestiture of Chrome from the rest of Google. And so there's a big fight about, well, can you really do that? Is Chrome really tied up with a lot of other things that Google is doing that not going to make it possible? DOJ is arguing it's mostly a standalone browser. It shouldn't be that hard to do. They also have, as part of their structural remedy, they have the idea of a contingent Android divestiture. That is, if in 5 years the competitive market isn't a whole lot better, then maybe you're also going to have to break Android up. So I think that's kind of the general picture, right?
Yeah, Lee jumped ahead, but gave us a lot of great information. I want to back up and just check a few boxes to make sure everyone is on the same page as far as what's going on here. So remedies 101 is that in antitrust, remedies are really hard to do. And so they're usually done over 2 trials or cases. And that's what we're talking about right now. So the first trial is they find them guilty of an illegal monopoly, which has already happened. And that the findings there, what they are guilty of exactly sets the grounds for, okay, this is the problem that we have to solve. We have to construct a remedy that fully resolves the problem with the illegal monopoly or attempt to. And so Lee did a great job in getting into the split between structural and behavioral remedies. I would like to point out that there has been an ongoing debate over this for decades. Structural remedies are preferred by everyone that cares about resolving monopolies, but they sound severe, they sound scary. Breaking up companies is something that rarely happens.
AT&T?
That's one of the few cases that have, and funnily enough, if you look at the history of the AT&T breakup, AT&T actually helped the government break itself up. It proposed the structure of the breakup, and the value of the pieces of AT&T were immediately more valuable from like an additive stock share than the company was prior to breakup. And then of course, AT&T re-conglomerated and is now basically where it was.
And if I can actually add something, because I think AT&T is an interesting model. Part of the reason that AT&T wanted to assist in that breakup at the time is because they also use that as a way to get rid of a lot of aged assets and problematic assets, which is part of the reason it helped the revaluation of the company, is that actually enabled them to get rid of stuff they had not been able to get rid of before. And that's one of the things is we talk about the notion of antitrust and breaking things up, especially in some of these kinds of technologies. Like there's several companies right now going and saying, we will buy Chrome right now. Well, all of those are AI-driven companies. Does that put us as consumers in a better place? Also, the fact that we look at Android, some of these platforms, pieces like this that are preloaded, it's because part of the way that they mitigate and manage the costs of those devices and what they're charging you is because they grab and scrape that data and then resell the data. It's an integrated environment. So in the potential of looking at a breakup, let's say that they take Android, put it over here as its own business unit. They pick up and they take Chrome away because so much of the Google environment is built into and around the Chrome browser. Okay, great. You can do and separate those things, and how much of a price tag is going to roll down to consumers, or how are the companies that have the ability and the technical infrastructure to do these acquisitions going to then leverage it? So this is not it's not a zero sum game.
I just wanted to add, it's like, I'm an old guy, so I did some lawyering around the time of the AT&T breakup, and my wife actually ended up working for one of the baby bells in this post breakup period. And one of the things that we have to remember, as Jim said, AT&T wanted to be broken up because it wanted to be able to get away from regulation of a lot of the local carriers, right? And they wanted to be able to actually compete in an unregulated market. So that was a big incentive for them to agree to the breakup. Now, I spent some time, a little bit of time, in the FCC trying to, which ended up sort of administering a lot of the things that the consent decree put into place, like waivers of services, agreeing on what the price would be charged to folks to hook into the local loop, all sorts of really sort of nitpicky regulatory issues that had to be handled in the aftermath of the breakup. And one of the things that was very, very clear is that even after the breakup, many of these entities were cooperating and also obstructing the ability of other entities in the marketplace. So, the incumbent local exchange carriers were always pursuing policies that were really hard with the competitive local exchange carriers to actually compete. So there's things you can write down on paper to say, we're going to do this, we're going to break them up, we're going to have these rules. And then there's an entire giant machinery of lawyers and agencies sitting behind the scenes trying to actually make that stuff work. And it doesn't, and AT&T is a great example of how it doesn't actually work, or it can actually fail now. But Matt was saying, like the pieces of Terminator 2, they've all just sort of like come together again.
The other sort of major category that we brought up, behavioral, the reason why it has such a low success rate, and there's been a lot of studies about this, is because it seems like a simple idea that the illegal monopoly was formed because they did something wrong repeatedly and you just tell them not to do that anymore. But as soon as you have that as a remedy, then all of a sudden you have to appoint someone to check, are they actually not doing that anymore? And every time they do something, the company has been sort of like lawyering, oh, we didn't actually violate, doing something different. And the person who's overseeing said, well, it looks a lot like you are still doing illegal behavior. And they would, and then there's this argument that happens every time. And you generally find that it's really hard to keep them from doing things when they really, really want to. They just find different ways of categorizing it and so on. So yeah, I think that we should kind of just dig into the questions here. I'm going to start us off, but I would love to get as many audience questions as possible. I will just start off. Is there anything that we can learn from past examples, like Microsoft, like AT&T, that is helpful in sort of determining what sort of basket of remedies we think the judge is going to decide, and whether or not those are going to be successful?
So Microsoft, I think, is another interesting case because again, we're technologically and business-wise much closer, right? We are into a company that is primarily driven around data and data processing, and having a tremendous amount of information, right? Microsoft's primary business, like if we look at Amazon, if we look at Microsoft, and if we look at Google, all three of them are primarily about data, data aggregation, and sale and management of data. We can talk about all three of them, and I think there are other business units and things like that, but it's primarily a data company. So then we have to look at all the technologies that they put out in front of us. So Microsoft, when they settled the suit around antitrust and negotiated that, you have to look at all of the concessions they made, many of which meant giving government back doors. There was a lot of privacy implications as a part of the negotiation that Microsoft then made a lot of money from as a part of those concessions. One could argue in many of those cases it didn't help remedy the antitrust situation. They just benefited from the negotiation. So that's the kinds of things I would be looking at is what does it mean in terms of privacy? The other thing I will mention is, so let's say that we do break up, right? They're a data company. They own a lot of data, move a lot of stuff back and forth. And because it's all in one consolidated environment, that means they're dealing with one regulated environment for PII, how they handle the information. But if, let's just hypothetically say, break up and take Android over here, Chrome is over here, maybe some of the other Google assets and things are put over here. Now these are all individual companies that are going to be licensing stuff back and forth. They're also not going to necessarily have the same kind of view on data, which means they're going to be putting your PII out there much more, selling it back and forth to each other. Costs will go up and there will be a lot of things moving back and forth that one can argue from a technological standpoint could create new risks, new problems, and not really remedy the problem.
Yeah, let me continue to amplify the privacy point. So let's look at, say, the conduct or behavioral remedies. One of the things that's going to happen as an adjunct to saying you can't do this, you can't do that, is also saying, but you have to share data with competitors. And so, for instance, there's proposals for syndicating like search results, which is the sort of thing that, say, if you look at a browser like Startpage, they get Google syndicated search results. If you look at a browser like DuckDuckGo, they get syndicated search results from Bing. And this is the sort of thing that people would say, okay, Google, you've got to share those kinds of search results, syndicated search results with everybody. And because most of that is not user data, the privacy issues with that are minimal. In fact, one of the things that's especially likely to be beneficial to consumers with no privacy impact is syndicating the Google search index, that is the snapshot of what it sees. Now, since that's all stuff that's publicly on the web, then there aren't really any user privacy issues. On the other hand, in this area of sharing data, people also talk about what about click and query data? What about what somebody puts in and now you're talking about what everyone who uses Google and puts in a question about anything, that getting shared out, and that's not publicly available. And so that begins to raise some interesting privacy issues. Now, it's a funny situation because there are already some compliance things that Google has to do with respect to the situation in Europe. And so they're developing like ways of trying to structure or trying to limit the set of data around the period that can be shared, but that goes beyond my level of expertise. I just want to flag that some data sharing from Google to its competitors is not going to involve what users do directly. In some of it is, and those are the things that get scary. The same issue, same kind of privacy issue, if you're talking about splitting from Android, is then, well, in this period of time where, let's say, somebody, what we would call a divestiture buyer, were to acquire Chrome, well, right now, Chrome is still a dominant browser. I don't know who you would say is worse or better, but in general, whoever picks up Chrome has an incentive to use the current advantage it has, which will be less than Chrome's advantage as part of it. It's still a big deal. And our concern, one of the concerns that people are going to be thinking about is that new owner going to be doing more nasty things to monetize user data, going to do more privacy based. Let me throw it back to you.
Yeah. I want to actually stick on this point for a little while because I think it's interesting. On the theme of remedies are hard to do, I think that, it's obvious that Google has been losing all these antitrust cases. A lot of folks in this space have been complaining about Google for a while, that they were sucking up the auction and not allowing competition. But at the same time, when you construct a remedy, there's a lot of unintended consequences that can happen, and it could leave things in a worse state if not done correctly. And I think one of the other proposed remedies also highlights this, and I wanted to get Mel's comment on it, but one of the proposed remedies is to end the default payment. So the payment that Google makes for setting its search as default search for other browsers. Mozilla is almost entirely funded by these payments. And they are, I think a lot of people would agree, a really good actor in this space of technology. And so the question is, are there sort of other dangers lurking in how these movies are being constructed that might impact or harm the environment, and how can we kind of potentially move on from these things?
So let's hypothetically say that Anthropic comes in and buys Chrome, right? There's a couple things that will happen because so many things in Chrome are natively built for the rest of the Google ecosystem and infrastructure. So if Google does not have Chrome, I mean, obviously it's a lot of the consumer browsers are based in, they're relatively agnostic to being able to handle and work across those platforms. Some things work better than others. But if you then look and say, okay, we're going to take that functionality away, that is going to have some technical impacts potentially on things that integrate Chrome into the rest of the Google ecosystem. So that now is going to go over, say, to Anthropic. And so they're going to bake a lot more of the AI tools and things into it from their AI world instead of Google's AI. So let's say that we do that, and now Google has to partner over. This is going to have a lot of implications for ads you see, where the data gets sold, what information you get fed from, the aggregation of search engines, how they look at it, because again, there will be more control by browser as to how some of that filtering happens with search engines. So law of unintended consequences comes into play very quickly.
I would just quickly point out that one of the interesting things that happened during the Microsoft cases is that they hard-coded the Internet Explorer into the functionality of the operating system, which made it literally impossible to divest.
And also it was useless browser to start with. So
Separate issue. But I mean, the DOJ's position right now is that because of the way Chrome's set up, it would be relatively easy to bring down things to break the Chrome browser off. But this is the reason why, one of the reasons why each phase, I think the guilt phase and then the sentencing phase. Even here in the sentencing phase, it's just, if you look at like Google's, the DOJ's slide deck on its proposed remedies frame, it's like 80 pages long. And it just goes into, there's a lot of expert testimony that's going to end up coming into play. The technical experts on both sides are going to be saying, this is easy, this is not easy. We can do this, no, you can't do this. So this is why antitrust cases, especially involving big companies, just get incredibly expensive. Honestly, the major tech companies, they outgun the DOJ itself. They have much more technical knowledge, and they know what they're doing better than what DOJ knows. So it's hard.
And one other thing I'll throw in there is I would say that Google's ecosystem is designed in a way that if somebody comes and forces that breakup, there's already a lot of engineering there to be able to how they manage that. So there's already been some of that thought that that is a possibility down the road, which means that they're already strategically well beyond government. So what happens, how it happens, again, no matter how you look at the different pools, companies, and everything behind it, Google obviously a long time ago took "Don't be evil" off the front of their company. But
Don't be too.
don't be too evil. But I would also say look again at where a lot of the money and funding goes behind Google, some of the projects they do, national security across governments globally, some of the concessions that are made in governments across. So
I just have one more question and I want to move to audience questions. Good thing, right? So, one of the interesting things about Microsoft is I think there's a consensus among the sort of scholarly antitrust community that the remedies were a disaster across both US and the EU. I remember my English professor had a copy from the EU of Windows. They forced them to sell a copy of Microsoft Windows that did not have Windows Media Player, but they didn't tell them that they had to sell it for less. So on the shelf, by law, is required to have next to the normal Windows minus Windows Media Player. And I don't think they sold a single copy of that. But it's also traced as being one of the more successful antitrust cases, and that's seems to be there's a law professor called Tien, who's I think coined the phrase "policeman at the elbow." That just the fear of all of this were put into Microsoft so deeply that they cut out a lot of their bad activity just because they didn't want to get sued again.
How much you believe that?
Yeah, and so the question is, do you think that this dynamic is still at play, or do you think Google is too savvy to be afraid of further cases, and that, I guess, the sort of like lesson that seemed to be learned that might not be correct, is the remedies don't matter that much as long as you kind of put the fear of God into the company. And then they'll behave better. But do you think that would happen again, or do you think that that was a one-time thing?
I think it's actually going to depend on a lot. Because as I started out mentioning, there are 3 active cases. So Google is not simply fighting one on one front. It's fighting in 4 or 5 different relevant markets. And I think at the end of the day, one of the things that's going to get really complicated is how do the different, depending on how the cases are not handled, like at the same time, the interdependence of between these kinds of areas. So I feel like Google is already settling quite a few of the smaller antitrust cases. But I think they're going to bet that they can do a lot of payoffs and buy themselves a lot of time in these areas. And they also can drag, there's just so many small and hard to see ways of fighting that will just buy them time. So I think that's the most interesting part about this is what will they be doing to get around to circumvent all of these any of the restrictions on them. And you would, of course, when you set up the actual agreement, you could try to cut off all of these retaliation provisions, all these circumvention provisions. How well will it work? In the Google DOJ has lots of technical committee to oversee the way this is going to go. I don't know how much that's going to work, but it's at least an attempt to have an ongoing combined sort of technical oversight of what they're doing. Maybe they need to learn some lessons in how to actually handle a big tech company that it has its fingers in a lot of different pies. I think we're more advanced than we speak about, but I also think that Google is such a many technical crafting on the also seems to all people.
So, and so the first thing I'm going to say here is some of this is the cost of doing business. You know, I mean, just literally, that's it.
It's a price thing.
It's part of the price tag of doing business, and you budget for it. I can tell you because I've been in those discussions. Not for Google, but for other entities. Some things are just the cost of doing business because it's cheaper to deal with that than it is to do the things that would take to accommodate it. Or there are business reasons that it makes things worse to accommodate that suit in the particular case. Or you're just in a position where regulatorily there's this case and there's this case and the two cannot be reconciled. I know because I've had to deal with a lot of those situations where you cannot be compliant legally. Just can't. You know you're going to pay one or the other, so which one do you want to pay? Which one serves? It could be a question of which one costs more, which one serves your customer better. The other thing is, especially in this world, is looking as it's not just one jurisdiction. It's not just the U.S., right? We're talking the U.S., we're talking Europe, we're talking a lot of different, the EU, we're talking a lot of different countries. And when you have an organization like this that is not only serving corporate communities, it's not only serving us as end users, and serve is a term I'm going to use loosely, to serve man, that's all I'm going to say. But when we're in that situation of that, they also provide a tremendous amount of service and partnership with governments. So the many-headed kraken here, while the DOJ is over here yelling about this, the DoD is over here asking for this. The NSA is over here asking for this. CIA is asking for this. So there are times that things that will come up in these antitrust suits conflict with the things that the government's asking for and saying, we need you to do these things. So there are times, I will not say that I know this, I'm going to say I suspect this, that we're going to fine you over here because it looks good publicly, and the money's going to come from the government to pay for the fine, and it's just going to go in a big circle.
I just want one point for your question, and that is also, there's a political dimension to all this, right? DOJ is an arm of the U.S. government, and it's an arm, and it's part of the executive branch. So we have, these lawsuits began before the current administration. We have seen how there have been upheavals within the various government departments. So that's an added degree of instability in trying to understand what they're going to do. I mean, so far, it feels like the DOJ proposed remedial framework has been fairly consistent with the way the case was originally brought. So, but right now, there's no clue or no sense or red flag that things are going to change in a weird way. But we do not know. And that also means, because of availability of that kind of political interference, Google is a very, very political actor. All of these companies are, and so there's also, you cannot rule out that there will be shenanigans on that side as well. So,
Adam, so if Google is made to sell Chrome, which is one of the plausible remedies, and if it's Anthropic or one of those sorts of companies, because those are mainly the companies that have said they're interested, and then if Anthropic maybe doesn't do well financially, which seems plausible for many AI companies a little bit down the road, they're not all going to succeed. Does that serve as something like a poison pill where Google couldn't buy Anthropic if Anthropic bought Chrome from them? Would that be a line they couldn't theoretically cross, or is that, they watched it, so it's fine now?
Yeah, no, that they would not be allowed to buy Anthropic. Whenever there's a large purchase, it does have to go through a merger review and be through the same agency probably, the DOJ that prosecuted the case. I would also just point out, since I was an antitrust lawyer, that when there is a divestiture, there are certain calculations that are made. One is whether or not it could be divested to survive on its own. That is a potential avenue. It would have to have a very high likelihood of success on its own, with the assets that it was spun off with the employee who was spun off with, et cetera, et cetera. It seems like more likely these days for buyers, that buyers will be assessed based again on their ability to run it successfully. And also, whether or not that increases competition. So like if Microsoft bought Chrome, that would not increase competition on Monday. So they would not be like a permitted buyer, almost certainly. And so it has to be, and also like they have to have enough money to run it. Like they're at the beginning, they're probably going to be losing money because they have to treat it as a new entity. They have to give it a big injection of capital to do that. And so there's just a lot of weird calculations that have to be made. And so it's not just like who can pay the most at the day of. They're going to be assessed based on their capabilities and whatever.
And the other thing I'll say is this. Okay, we divested Chrome. We're out. We have competition now. So now we started building Silver, the new browser by Google, because there's competition now that we can go compete with unless that divestiture prevents them from entering that business for a period of time. Then what you do is you take and you go form a brand new company that's invested in, you go build the browser you want to go build. So, because again, if you have enough dollars, this is corporate structuring, right? This is the game we're playing. This is corporate structuring. It's where do I put the dollars? Who has the ownership? And when you're playing with public companies, you can have all kinds of fun with where stuff goes and the agreements you sign. I'm here to be Betty Buzzkill. So
Well, you went to school for it. Is that not something that would be preventable by the breakup? Like, and you also can't,
That's right. You're going to
Yeah.
try to write in as many guardrails as you can. And there should be a way to actually, and I'm not the expert on how these get structured, but I would think there's probably going to be a way to adjust these over time as the agreement is overseen. I mean, as I mentioned before, the current DOJ proposal doesn't say divest Android. It says it's got its proposal for contingent divestiture if after 5 years the divestiture of the remedies that they actually put in don't increase competition, then that may come into play. So what that tells us is you've got to continuously be monitoring what's going on in the marketplace and watching out for these kinds of interesting corporate restructurings where, like, yeah, we sent this ex Google guys now like raised a bunch of venture capital for a browser that's going to be brought in, or maybe that's not the thing they need to do. But all of these, you have to, any good antitrust enforcer is trying to figure out how not to be more than 2 steps behind Google.
Yeah, the drafting of the actual final agreement is an art in and of itself. And the DOJ and FTC attorneys in charge of this and usually much far above their weight, but at every step of the game, they are outgunned and outspent legally. And so while I think that, I never criticize the capability of the DOJ FTC, they just don't have the comparable manpower necessary to like think of every potential vulnerability of the agreement and draft out of it. And there's also a lot of cost calculations that always get made. Like, if you have to appoint someone to oversee it, you have to pay them, who pays it, all of this stuff has to be baked in, and it becomes very complicated quickly, and it becomes harder to manage very quickly. So simple is always better, but in terms of actually being able to do it, but it also means you have more unintended consequences. It's just it's a huge task to do these things.
Understood. Thank you.
Hi. So I'm curious, like, how effective of a remedy is it to actually divest Google Chrome, or even to do the thing where they can't pay people to put their Google in the browser? Because I guess I'm thinking about it, like, I think of Google as primarily most of their money is coming from ads, and from specifically, their AdWords. And I don't think Google Chrome affects that much. Like, if they divest Chrome, like, is that really a big hit for them? And then I guess as a follow-up question to that, like, are there any, I understand antitrust is very hard for a lot of reasons. Is there any like regulatory or other sort of mechanism, that would be less costly to the government to sort of achieve some of these same ends?
I can kick this one off. I honestly, in sort of the mantra of simpler is better, divesting from is simple, it's easy to administer. There's less risk of, having the problems with behavior remedies. So I think that makes it a very attractive solution. But I think you are correct in that the problem is largely due to dominance in ads. And I think that most customers know Google and they enjoy Google, and until they voluntarily choose different options, it's really going to struggle with competition to get a similar spot.
Stop. And this is why I mentioned that there are other lawsuits, right? The antitrust lawsuit that Judge Brinkman's got has to do with ad tech and everything that Google does in advertising, all the basically after they acquired DoubleClick, all of the way they were able to dominate that market. But the facts are from from this case that a great deal of the search advantages and the search monopoly is due to the fact that you have Google search is the default browser. Google search is the default search engine in these browsers. And so you have to at least take away some of the advantages that Google has obtained through its various exclusive and anti-competitive agreements. So it's kind of like first you handicap them a little bit, and then you handicap them somewhere else, and then you handicap them in another place, and you see how these things add up. And as we mentioned, FTC and DOJ are both part of this. So it's sort of an integrated, when you are setting up this kind of a consent decree, it is essentially both. So it's almost sort of like a special administrative set of regulations for Google because it has that degree of market power and concentration. So there would still be the FTC will always, and whether the FTC will be effective over the next several years is an open question. But in theory, you have everything that comes out of a particular antitrust state. It doesn't subtract from the other kinds of administrative oversight or administrative powers that the agencies have. The question is really how do these things interact? But I think no one, and Google is going to argue very hard that this isn't necessarily going to effectuate any actual change in the market. But this is why these things are such a tough.
And if I look at it purely from a market standpoint, a little bit of a technological standpoint, right? So if we look at a lot of these cases, this notion of, okay, well, they own too much of the overall market. Well, why is that? Because they've gone to go fill certain consumer needs, certain business needs, certain government needs. They're doing that. So it's not only they've done that successfully, there are other options in the market. They just have the funding to go back in and say, nope, They've become a preferred browser. I personally, there are applications and things that I do that are built and optimized for Chrome, and some things that those applications don't work on another browser than Chrome because of how the technology is coded and developed. But that was not a decision of Google. That was a decision of those applications. Now, some of those applications got some funding and investment from Google and some of the funds that they kick into, but they built the code and it was optimized for those situations. But beyond that, so let's take Chrome away, right? It's an independent company. We now have a company called Chrome. It's a browser, right? It's hard, I mean, as Mozilla knows, right? It's hard to make money as a browser. It's a tool, right? There's a lot of options for the tool. So if you don't have the level of investment, what then happens? Does Chrome stagnate? Does it degrade? Security is a huge problem. Where's the money and the revenues coming from? And so now they're going to probably pull in ad space from Google and Microsoft and everybody else. Oh yeah, they already did that already. What's the major benefit and value? And that's one of the big questions, right? We took it away. We created more competition. Did we? Because people prefer the browser, it continues to be developed and continues to have the pathways and the revenue streams. Did that create new options in the marketplace? Just because you took it away, is that remedy something that helps? Or is that just shedding something that really is not going to necessarily hit the bottom line? Again, I don't remember if Chrome is actually even a profit center at this point, or if it's just a cost of doing business.
And just just to hit on the last two questions, I think that in terms of, I don't like the remedy of barring them from paying for browsers, because I think if you leave the market as is, Microsoft is just going to bid for it being the default, and Microsoft is itself often a monopoly, and they've been wanting Bing to be a monopoly for a long time. I do kind of like choice screens, which is another proposal. It can annoy customers for all of 15 seconds, but
That's important.
it does make them think and and really assess their options. And so like my organization is running a de-dueling experiment. We're trying to replace all of our tools with open source and encrypted when possible tools, and some of the stuff actually we pay for Catch, which is a privacy preserving search engine that you pay for it instead of serving ads. So the pitch is that we have zero incentive to track it, even unintentionally, because you're just paying us directly instead of us having an ad supported search engine. DuckDuckGo is a context advertising privacy preserving search engine. So there are other options out there, and a lot of them are just have their own sort of benefits. It's interesting to test out these things.
So, I want to ask a question because again, I do a lot of stuff in open source, these various areas. How many people are ready to go spend money every month to license a browser?
Maybe.
How many of you are willing to pay $20 a month for your browser? To not have to put up ads. How many are then ready to go pay another $20 a month or $10 a month for your email? How many of you are ready to go then pay another, let's call it $10 a month for, because again, your licensing, Microsoft, Google gives it to you because they're scraping it. Unless you're again paying license fees. So again, you're now racking up pretty quickly. How are you willing to pay for it? You're paying for it one way or the other. You're paying for it with your data, you're paying for it with money, or as we see with Netflix and Hulu and a bunch of them, you're now putting up with ads and paying. So, again, these are the questions. What percentage of the population are ready to pay for it to then create that opportunity for competition?
I just want to say it is really the question the bottom line question for all of these remedies is, will they do actually improve competition? Will they actually reduce barriers to entry? Will they actually lead to more user privacy? And these are multidimensional. It's not just, as you say, breaking Chrome off by itself would not be enough. So there's an entire legal infrastructure of remedies that's actually needed to support the promotion of competition. And what is difficult, again, because I do the legislative stuff, the political aspect of it is, how do you maintain any of that over a long enough period of time and with consistent signaling to market actors where they actually take the threats of enforcement seriously so that their behavior actually changes. That is a tall order. On the other hand, the status quo is clearly very, very bad. And so then you're asking the question of, how much are we all collectively in various ways willing to pay in order to try to get a better future?
So my question was about the unintended consequences of the AT&T breakup. I think one of the tragedies most was that Bell Labs was kind of died out of that, and it's kind of storied history. I don't know how accurate it is, but a lot of research and technology came out of that. And arguably, from Google being a monopolist, we have gotten weird benefits. Like large language models was a research project because, frankly, they had a lot of excess cash from being a monopoly. Are we potentially also killing research efforts along those lines? And is there, I don't know, I haven't read through all the remedies, but considering those types of aspects in the proposals?
So looking, and because I've dealt with various forms of generative AI, business intelligence stuff for a very long time. That's been a large part of what I've done and dealt with. When you look at that and where things came from and how the models and the technologies have been developed, they're very expensive to do and to build. So the number of players that can do it, either A, you've got a very small, very brilliant group of people that are willing to put in the time, the hours, and make all of that happen, and then try to find the funding and the capital from the right people that will help you get it to market. Or you've got certain companies of certain sizes that are willing to go burn capital and cash to see what happens. Because in my experience, one of the things I have seen and had to deal with consequences of is something that goes from being guardrails to being a third rail.
One other thing I wanted to add onto that is that, competition is the policy of the antitrust laws. The economic theory around competition isn't stable. So, over the last 30 years or so, there's been a lot of folks will talk about Schumpeterian theory and monopoly capitalism, and the idea that you actually need some level of concentration and monopoly in order to fund these kinds of research efforts. It's also the case that that's part of what ends up justifying a lot of intellectual property law, right? That actually does confer certain kinds of monopolies on those who develop technology. And so there are entire debates about the patent antitrust intersection and how these things work together. But all I wanted to say is that is another tool of the system that attempts to provide incentives for research and innovation, intellectual property that can coexist, although not without a great deal of tension. But it is also, I think, sort of an essential tension in this area. There's always going to be this question of how much slack, how much extra surplus is needed in order to get the right level of research investment. And economists argue about that all the time.
I would just add, so we don't have a ton of time left, but one of the interesting things to me is that a lot of the theory of interest, why do we target monopolies or why this fight, was built on a theory that was like almost 100% reproducible up until the modern times, which is a stagnant company, quality would go down, prices would go up, choices would go down, they wouldn't innovate, they would actively oppose innovation because innovation is expensive. And there was a clear sort of through line for customers, like any monopoly or any transaction would happen.
Well, AT&T, you know,
Yeah.
like stagnant, that the telecom industry was stagnant, incredibly stagnant for so many years. I mean, you know, wow, you can get any Western electric telephone in any color. You know, you didn't even get any, you didn't have, you would not have gotten the innovation in telecom. That
Yeah.
without that breakup.
Google is kind of a weird monopolist, like you said, they do a lot of investing, they do a lot of long-term thinking, and so it kind of raises this open question of, like, there's a lot of complaints in the market from competitors, about not being able to like grow new Googles, which I think is 100% true, and there's a lot of potential values being lost because it's less apparent for customers. So there's always that risk, especially with remedies, that you're going to do something that doesn't work and pisses people off and sort of like gives Can You Trust a bad name. And that's one of the things I've been anxious about. But I do think that like it is still valuable to go through the exercise because Google is acting like a different kind of monopolist, and there's probably different that have to come up with that. And I also have my own personal theory as to why Google behaves differently at that time.
Well, and the only other thing I would probably add to that again is we as consumers are way more involved and have way more power with these services than we used to, right? So this is part of it is when we find somebody that's servicing the need in the way we're willing to pay for it, accept, people will flock to it, right? And then we have the communities that will go the open source route, support the open communities. But let's be honest, most people are lazy. They want to go simple. They want to go cheap. They want to go free. Nothing's free, right? Data costs, all the rest of these things cost. So the other thing I will say is that in the age of LLMs, what's happened in the last 2 years is that investors are not willing, VCs are not willing to pour the same kind of capital behind technology that they were a year ago because they're going to say, well, AI can do it. They don't necessarily understand it all well enough. And so, you know, like Microsoft just had this conversation yesterday, is laying off a third of their team, their staff. Everything else like that. So what we see is the amount of capital people are willing to pour behind it, which means the tools we're going to get are not going to necessarily be as mature for a long while. Because again, what people are going to pay for.
And we have not even been talking about the markets for talent, the markets for, you know, who hires who, where do the smart people, the best people go to work for. And you know, that is actually one of those areas that will do a great job into hiring for a long time.
All right, we're at time. Thanks everyone for tuning in.